all human beings are born free and equal in dignity and rights.
Human rights would be one of the foundation stones on which peace could grow.
There are hundreds of human rights activists who are struggling to achieve their goal of peace, education, and equality.
We're living in a world where human rights become an international issue. But here, in a sense, the United States is out in front because it has a statute called the Alien Tort Statute.
It all started with a French diplomat. In 1784, François Barbé Marbois was assaulted on a public street in Philadelphia. The incident prompted Congress to enact the Alien Tort Statute in 1789. The Alien Tort Statute, or ATS, empowers U.S. courts to decide any civil action by an alien for a tort only, committed in violation of the law of nations or treaty of the United States. The statute lay dormant for over a century. However, in 1978, one case forever changed how the statute could be used. In 1976 in Paraguay, 17-year-old José Filártiga was kidnapped and tortured to death. His father, Joel Filártiga, was a well-known critic of the dictator Alfredo Stroessner. Later, José's sister, Dolly Filártiga, moved to New York. There, she found Americo Peña-Irala, the man who had tortured her brother to death. The Filártigas sued Peña under the ATS for wrongful death. The case reached the Second Circuit and the Filártigas were awarded $10.4 million in damages. The case marked the start of an era. Over the following decades, human rights advocates used the ATS to bring claims in U.S. courts, winning some 24 cases. Then, in 2013, another case would redefine the ATS just as radically.
We'll hear argument first this term in Case 10-1491, Kiobel versus Royal Dutch Petroleum.
Our agenda is clear. The United Nations has said it, that this environment has been degraded. The world has said it, that our resources have been stolen. They have carried out an assessment on this environment and they have said that human beings should not and cannot habitate here.
In the Niger River Delta, Royal Dutch Shell produces 2 million barrels of oil per day. A small part of this region is home to the Ogoni ethnic group. Shell's activities have contributed to severe pollution, destroying farmland and exposing locals to carcinogens. In 1990, the Movement for the Survival of the Ogoni People was founded to protest Shell's actions.
We are going to demand our rights peacefully, non-violently, and we shall win.
Multiple letters from Shell to the Nigerian military government made it clear that Shell wanted the government to take care of Ken Saro-Wiwa.
Most of leadership that was part of this game must be arrested, and the security forces are out doing just that.
It's not a case where the corporation was doing its best in a country which did bad things. The company and the military dictatorship were working hand in hand.
An unknown number of civilians died in the resulting crackdown. 9 local leaders, including Barinam Kiobel, were executed after a sham trial. A group of survivors, including Barinam's wife, Esther Kiobel, sought damages under the ATS. The case reached the Supreme Court.
It is implausible to suppose that the very first Congress wanted their fledgling republic, still struggling to gain international recognition, to be the first such country and to open their new courts to suits by foreign plaintiffs against foreign defendants for wrongs occurring entirely on foreign soil.
The court held that the ATS does not allow courts to decide cases based on violations occurring in other countries, unless the violations touch and concern the territory of the United States. Concurring opinions suggested that the ATS might still apply if the defendant is seeking safe harbor in the United States. The decision created a shockwave in the legal community. Some were happy to see the end of an ineffective means of solving global problems. Others view the decision as a catastrophe, while still others hope the ATS might still remain useful. Despite these divergent reactions, the Kiobel decision was unanimous. All the justices agreed on one point.
This case was filed by 12 Nigerian plaintiffs. What business does a case like that have in the courts of the United States?
The majority had a further contention. They placed great weight on the presumption against extraterritoriality, which states when a statute gives no clear indication of an extraterritorial application, it has none. But while these concerns are real, there were also real consequences to the Kiobel decision. The victims were not compensated, and Shell was not held accountable. And there were even bigger effects. Immediately after the court's decision, stocks in companies accused of human rights abuses rose dramatically. A real deterrent to abuse was removed. As the Financial Times said following the decision, corporate lawyers the world over may be breathing a sigh of relief over this one. In the years since, the ATS has been further circumscribed. In Jesner versus Arab Bank, a 5-4 conservative majority ruled definitively that the ATS can never be applied to foreign corporations. Human rights advocates operating within the United States have had to turn to other, more limited laws. Meanwhile, Ezra Kiobel has taken her struggle abroad.
I still feel pain in my heart that my husband was killed, and I need justice for him and my people.
She and the other plaintiffs have sued Shell in the Netherlands. They also sued the law firm Cravat in the US for refusing to turn over documents they acquired while representing Shell. Kiobel and the other plaintiffs lost that suit in July of this year, but the case in the Netherlands is still ongoing. It has now been 23 years since her husband's execution. But is the ATS completely dead? For corporations, the answer seems to be yes, but many jurists believe that the Kiobel ruling still left certain doors open.
And there are those who think, no, I've slanted this in my own direction, which is more open to use of the statute. And others think, no, I haven't, it's more flexible even than I think.
The ATS has had a long and dramatic history, but its future remains open. Whether the ATS fades into obscurity or reasserts itself as a beacon of hope for human rights around the world will be for the next generation of lawyers to decide.